Those of you who have been to our seminars before, we're going to switch now and do the blue question sheets. Because we have 230 people here today, what we've done is we've come up with a process where we can try to answer as many questions as possible. And so I go through the blue question sheets as quickly as possible. And I have a couple here already. A few things. Somebody emailed me over the weekend, so I want to start with him. Thank you. The question from this particular board member was, our architectural committee sometimes conditionally approves items when they make a decision. And I don't have a lot of specifics on this particular conditional approval. And the question was, is that something that's okay or valid? And I guess my answer on that would be, well, it depends on how they're conditionally approving it or what they're conditionally approving. So it's okay to conditionally approve, saying like, we approve this addition so long as you get the proper permitting from the city. That's okay. Sometimes you may say, we conditionally approve this so long as you work something out with your neighbor. Because I think in this situation, there's a view deck that might be encroaching on the other neighbor's privacy. I don't have an issue with that. As long as there's a good basis and there's no discriminatory behavior for that. So for the most part, I think a conditional approval is okay. One thing I want to caution you about as an architectural committee is when you get the applications, make sure you either approve or deny them in a timely manner. We had a case recently where the board was just trying to be nice, but what they did is the homeowner submitted something for a complete renovation of the house, and they basically did like hand drawings that were horrible. And the board said, we need more information. They didn't approve it, they didn't deny it, they just said, we need more information. And what happened is, they also had a section in their CCRs that said, you have to, as architectural committee, approve or deny an application within 30 days. Well, this person never got back to them with the additional plans, and guess what? It was approved. And it's not something that this association wants or likes. So just keep that in mind when you're getting these applications. If you're an architectural committee member, your board serves as the architectural committee, be mindful of the fact that, okay, even though it seems kind of unneighborly to say denied, you really should if you don't have the information that you need to make your decision, okay? Let's see, the first question. Thank you. A recreation club is formed by members of an HOA community, a 50, looks like 50 plus, I think is what they're saying, community. They elect a president, a secretary, and a treasurer. They also raise money by organizing functions, such as sales, luncheons. Does the rec club need to file a tax return? Check with your CPA, probably yes. Is their club required to report income to the HOA? It depends. It depends. It depends how closely aligned they are. It depends if they're like a recreation club that's part of the association, so I can't answer that one directly. What should the relationship be between the club and the HOA board? Money raised, rules for spending, carrying out activities without consulting the HOA board? Yeah, whenever we have these recreation clubs, and these are typically for the 55 and over communities, you really need to evaluate at the outset, what is the relationship going to be between the club and the association? Because issues come up in terms of liability, liquor licenses, insurance, and all of those need to be explored before that recreation club is formed. Typically, I like to keep it separate from the association, as separate as possible, because it's hard to control a recreation club. It's hard to make sure that the finances are being handled properly, etc. So we prefer to have it separate. Can the board bring in an outside educator or consultant to speak to the board without this being declared as an open meeting? Can the board go off-site for such a meeting? Yes, yes, yes. Okay, I have this question a lot. I'm surprised somebody hasn't asked it yet. Is my board violating the open meeting law by being here today? No. As long as when you're driving back, you're not talking about Johnny Appleseed, right? So you need a quorum of the board discussing association business to be a board meeting. So can the board bring in an outside educator or consultant? Yes. Does it have to be An open meeting? No. If you bring in your attorney, that could be an exception under the open meeting law for executive session, advice from your attorney, so that would be one exception. If it's somebody else, like a reserve specialist, then it really does need to be an open meeting. Can the board go off-site for such a meeting? Yes. I have some boards, especially some really highly functioning boards that just really do a great job. They might even do a retreat every year for their board members, where you go off-site to maybe a room somewhere and you try to talk about goals and large projects that your association may want to do in the future. Can the HOA implement standards for supplies in rental units? The performance of air, heat, refrigerator, etc. Thank you. Can they implement standards for supplies? You know, I'm not really sure I understand that. I think it would, if you're gonna implement special procedures for the rental units, I think that would be something that would need to be outlined in your CCRs. At what point are improvements to the common area and replacement of equipment considered to be capital and require homeowner approval? Really good question. Why is this important? Because sometimes in your bylaws or your articles, there will be a provision that says the board cannot spend X dollars, typically it's $5, $10, $15, $20,000, without getting membership approval. You know, so they can't spend money on capital, long-term capital improvement without getting the vote of the membership. So at what point are they, the question is, at what point are improvements to the common area considered to be capital and require homeowner approval? It depends on what your documents state. So I would look first at, you know, what does your assessment section say? Are you going to have to do a special assessment or increase your assessment to cover something? I'd look at your bylaws to see if there's any spending limitations. Those are all good suggestions. Next question is, per our bylaws, the board has a limit of $2,000 per expenditure with owner approval. This is a different association too. Our board approval has reserve allocations for major projects, specifically asphalt, landscaping, and irrigation. We will be doing major asphalt this year. Do we have to get a majority owner approval to do this project by a special meeting? Yes, you do. If your bylaws say you have to, there's a board has a limit of $2,000 per expenditure without owner approval, yes, you do. You might want to amend that section. That's very, very low. I bet those documents were written in the 70s or 80s. Okay, we know that our HOA does not have to be incorporated. What? Okay, this association needs to talk to me. Your association does, it should, best practices is that you should incorporate. Okay, what are the benefits of being incorporated? Well, a couple things. A, please, any association that's sitting here, please incorporate if you're not already incorporated. The reason why this is so important is because if you're not incorporated, every member of your association has individual liability for the actions of your association. There's no corporate veil. So if your association screws up on something and there's, you know, some sort of problem or a drowning in the pool or a trip and fall and it's not covered by your insurance, guess what? They could go after any individual owner to repay that debt. So it's not good business choice at all for associations not to be incorporated. So A, if you're not incorporated right now, please get incorporated. It's very inexpensive to do. You have to file an annual report every year. It's $10 to do that. For those of you who are sitting here thinking, oh, I'm incorporated, I don't need to worry about that. Well, check to make sure your management company is filing your annual report every year. Because sometimes the management companies are messing that up. And there's something, you can go to the Corporation Commission website, and the website allows you to do a reminder for your association, 60 days before it's due. And maybe you have somebody who's responsible on the board get that reminder. Okay, we have owners that rent their properties out. They do not supply our HOA with any information. What would you suggest we do? Okay, first things first, notify them of the law and send them a demand letter asking for that information and charge them the $25 fee. They have to pay it, they have to provide you with the information. If they don't provide it to you, then you can charge the $15 as the penalty. You might even want to knock on the door and ask the renter for the information directly if you feel safe doing that. Like I said earlier in the presentation, if they refuse to provide it to you, you know, you're in kind of a tough position because you got to sue them to get it. And really for those 3 categories, which, you know, is hardly anything, is it really going to be worth it to do that? What is the best way to address neighbor-to-neighbor disputes that continue to send in violation complaint forms on each other? For violations that can't be seen by management. Loud cars, dogs, etc. This is funny. This is a very common problem where the association gets stuck between a Hatfield and McCoy situation. A couple things. On pets, barking is typically what we see, or maybe dangerous dogs. Ask the owner to put it in writing that's complaining about it. And then especially on barking, sometimes some associations have like a 2-owner requirement before the board will take any action, and the board could be required to have to do something under the nuisance provision in your CCRs, meaning that the association shouldn't allow a nuisance to exist on the property. Sometimes the cities will help with the dog barking problems. I know like the City of Surprise is here today. We welcome them, and you know, sometimes the city, you can contact their neighborhood services or neighborhood outreach department. They may have something special that you can do to handle mediations or dog barking issues. We found that the police typically will not get involved in that in our experience. And the association, you know, it's difficult, especially when they're fighting between the 2 of them. It even gets worse when they get injunctions prohibiting harassment against each other. Seen that too. So, you know, I would say look at it as objectively as you can on the violations, and for the true violations, I think the board does have an obligation to act. If it looks like it's just a harassment thing, maybe bring in your attorney to get some advice as to, you know, can we write them both a letter saying, you know, you 2 need to go along. Here's some resources through the city to do a mediation so that you 2 can sit down and work out your issues. But effectively, the association's not getting involved in this situation. What is the approximate cost for your firm to assist in foreclosure for unpaid fines? Foreclosures typically cost about $2,500 versus the Justice Court, which is usually about $900, just, you know, in attorney's fees. The open meeting law. If a meeting is announced via signage, does it have to be posted at every entrance? Good question. No. So you can just post it at one entrance, just as long as everybody knows, hey, that's the entrance where we have our postings for our board meetings. Board removal. If removed, how long does the removal member have to wait before running again? I love these questions. These are great. And I want this person to know we're not laughing at them, we're laughing with them because it's crazy. Okay, so there was a law that was introduced last year but didn't pass, which put a time period that the board member would have to wait before they could run again after being removed. That did not pass. So the board member, and I've seen this happen. I actually have, this is so crazy. After doing this 20 years, I have the best stories. I had a removal meeting where the entire board was removed, okay? And after the whole board was removed, we have to elect a new board, right? And so the 3 out of the 5 board members threw their hat in the ring to run for the board again in 2 weeks. And guess what? They got elected. I mean, really? Typically these removal meetings, just so you know how expensive and divisive they are for the community, they typically cost between $5,000 and $10,000. Talk about a waste of money. I mean, they remove these people and then 3 of them get back in, they have the majority, so it was just wasting money. Crazy. Okay, how to deal with an abandoned condo in the community. Oh, that's a good one. So we think the condo's been abandoned. What can the board do? Well, the first thing that I would do is talk to your attorney. What I would do is usually when the condo's abandoned, guess what? They're not paying their assessments, right? So I would do some checking. I'd check to see if their property taxes were paid. I'd check to see if the bank is foreclosing on them. I'd run a credit report on them. Try to get a snapshot of what's going on. Look for alternate addresses. We have a couple of different systems, Accurate and Merlin, where we can trace where they've been the past 30 days. I try to figure out what's up with them. Sometimes we find out that the person's passed away. And then we have to strategize, do we want to wait for the family to come in? Does anybody have any contacts with the family? We typically will lien the property, even though that sounds a little bit harsh. It's a good idea to lien it just to protect our interests so that we're in the know if anything's going to happen on the property. But so how to deal with it? I would do your research. You can try to figure out what happened here. If it's not secured, you can call the bank and tell them it's not secured, and they will come out and secure it because they don't want their investment to have, a bunch of, people that shouldn't be in there, being in there. I think we got to look at it on a case-by-case basis. If it's not being maintained, do we have a self-help provision in our documents that allows us to go in and maintain it? Let's see. Oh, and she even put some more information. Owner died. Family wants nothing to do with the property. Owner died penniless. No mortgage found. Wow. Okay. That's why I love these collection matters. Okay, so owner died. Not good, obviously, whenever that happens. We suggest typically liening the property if they owe money, unless the family reaches out to you right away and says, hey, we know, we just need some time here. Then you want to work with the family. But this person, it says the owner died, family wants nothing to do with the property. But the interesting fact is no mortgage, right? So that is like light bulbs and fireworks are going off in my mind. If they owe money to the association, that's a foreclosure right there. And so that's something that we should consider foreclosing on. Let's see, the next one, in a gated community, condos. Should community services, the gatehouse, not restrict a vendor from entering the community if the owner has not gotten approval from the board to do work inside the condo? This is kind of a sticky wicket. I know this association. So this particular association wants to have approved vendors only working within the condo. And so the question is, can the board turn away an unapproved vendor who is a visitor going back to do work on the owner's property? I know the board's not going to like this, but I think you have to be really careful about that because we're mixing up the issues. The issue is, hey, you're not licensed by the board or whatever the requirements are in the documents. I don't think that we can turn them away, but I think that that's a good time to contact the owner to say, hey, this person, we're guessing that they're doing work in your property. They're not licensed to do work in your property through the association with the proper bonding and insurance or whatever. Please provide that to us right away. But I know I can hear this board is probably going to say back to me, well, but that doesn't have any teeth. What has teeth is telling the vendor to go away. So I think you might be causing a bigger problem for yourself if you turn them away. Would there be any liabilities such as paying the owner for the vendor's trip if the vendor was restricted from entering? Possibly. If they go to small claims court or justice court, a judge may say that was unreasonable. In regards to the open meeting, can board members meet to plan a meeting, such as items for discussion, things to be voted on, but no specific discussion about the item? Would such a meeting need to be posted and open? Yes, it would be. Now the way around it, the loophole is just have less than a quorum have this pre-meeting. Okay, less than a quorum, that's your way around it. If you want to have a meeting to plan the meeting, have less than a quorum, or you could have one board member poll the board members individually so that you're less than a quorum doing that. How specific must language be to prohibit rentals? Oh, okay. Our documents currently state you cannot conduct business on the property. Hey, this is a really good question. Okay, it has to be very specific. Under the law, there's a bunch of cases in Arizona and around the country that say that if you're going to do a rental restriction, and actually one of the handouts that I gave you, amending association documents and implementing rental restrictions. I just kind of put this in here as a bonus for you. On the back, flip side of this, talks about rental restrictions, and it talks about a very important case in Arizona called the Vales case, which upholds an association's ability to implement rental restrictions. Basically, if you're going to do a rental restriction, it has to specifically say no rentals. Or it may grandfather current owners and say no rentals in the future other than the current owners. This no business prohibition, that does not allow you to prohibit rentals. And there's case law that says that is not going to allow you to prohibit rentals. Okay, guideline for fees charged for violation of CCRs. Ooh, I'm guessing you're thinking like fines. It depends. I hate to say it depends, but it really does. Make it stiff enough of a penalty that it has to be reasonable under the law, but make it stiff enough so that they won't do it again. So for example, maybe on trash can violations, it starts out at 20, goes to 50, then to 75. But for parking an RV in your association over the weekend, make it stiff enough, high enough that they're not going to be able to pay less by getting the fine at your association versus parking at RV World, right? So you kind of have to think about that. Also on rental violations, if you have somebody that's renting their property in violation of your CCRs, make the penalty the amount of the rent. I've argued that in court and won. And so basically it's a wash for the landlord. It doesn't make sense for the landlord to rent the property. Are political signs supporting candidates permitted by law in Arizona? Yes. We have to allow political signs, especially now we're in this big election push here. There's a time period that we can keep the signs up, that they're allowed to keep it up. I can't remember the exact date. I think it's like 3 days before or 5 days before and 70 days after. But short answer is yes. The board does have to allow political signs in a planned community. That could be on that owner's property. In a condo, it's going to be in that owner's window. Sometimes we might want to forgive late payments in extenuating circumstances, such as a loss of a spouse, illness, loss of a job. Can this be a risk for the uniform rule? No, that's fine. I hate to say that we're wheeling and dealing on these collection files because we're not, but there will be times where we have to make a business decision, just like any other business would, that, okay, this person owes $1,000, their credit's horrible, they want a one-time discount of $75 or $750. I would probably advise my client to take the $750 and run. And there will be times where you see hardship situations, where there's a violation on the property or they're not, able to pay their assessments in time. Of course. We want associations to have a heart. I'm not up here saying, no, that's the time to really stick it to them. No, I'm not saying that. What I am saying is, maybe there's some other things that you can do. I've had some associations where we had one particular owner who had a very long-term illness, and the association did a bake sale, and they raised like $800. And that same association for her, the same association, every Saturday, a group of men in the association go in and clean up her property for her. So, we've got to have a heart here. We're communities. So keep that in mind. What do you do about a renter that is trashing your neighborhood? Is it true that you cannot contact the owner, just the management company? Good questions. Okay, what do we do about a renter that's trashing your neighborhood? A, fine. B, contact the landlord with specific evidence of what the tenant's doing. It's been a very effective strategy that we've used, and like I said, typically at the end of the call, the landlord's saying, can I hire you to evict the tenant? Can the landlord say, you have to deal with my agent? I don't want to deal with the board, you got to deal with my property manager. Yes, they can. Under the law, they can ask that. However, our firm suggests that we still continue to copy the owner on everything so that they're kept in the loop. House Bill 2513 has this passed. No, so all the bills on this particular sheet that I gave you have not passed. These are pending in the legislature right now. And if you look under the status column, it'll tell you where it is in the legislative process. And at the end of the legislative session, we'll do a cheat sheet that we put on all of our social media, and if you're on our mailing list, we'll send it to you with our Mulcahy memo, indicating which bills do pass for that year. Can an individual who has a power of attorney or medical directive act in the place of an individual who has been temporarily incapacitated, paren alcohol, regarding fines or bad behavior. Okay, so if somebody has a power of attorney, can we go to that person regarding an owner who is incapacitated regarding fines? I mean, of course you can go to that person, but the owner is ultimately responsible. So if they have a power of attorney, you can talk to them about it, but there's probably not much they can do about it. And I don't know who was the cause of the fines, whether it's a tenant or if it's the owner, that owner themselves. Can owners request to see certain documents without the 15 cents fee? Good question. I'm sorry I didn't make that clear. An owner can come in and just request to see the records without having to ask for copies. So you have to put them in a place where, you know, they can look at the records and give them time to do that. If you're an association that doesn't have a management company, I offer for free. You can have them come down and look at them at my office in our conference room. Most of you may have a place where you can, you know, put the owner that's requesting it. One thing that I'm just going to mention, because like I said, I have some really good stories over the past 20 years. I had a particular association where this gentleman came in to do a records request, and we have a rule in our office that we say, you know, you can't take in jackets in the conference room, no briefcases, you know, the whole deal. And so he was apparently stuffing documents down his pants. And our receptionist called me and said he just put something down his pants. So I went in there and I said to him, you know, I have this information that you have, you know, documents down your pants. I said, either you take it out now or I'm going in to get it. Literally, he turned around, pulled his pants, you know, and took it out and gave it back to me. I was like, oh, do I have to touch this? Yeah, all right. Let's just day in the life of a community association attorney. Okay, can you go over the recent changes in case law that do not allow the association to have credit reports unless the association has already obtained a judgment against the debtor? Good job. Okay. So there is some case law around the country that says that there are certain credit reports that you can't obtain until the association has a judgment against the owner. Now, that may be just like the 3 credit reports that are issued by the 3 credit reporting agencies, but there are a number of other resources, and that may be accurate. It's not the law yet in Arizona, but that may be accurate in other jurisdictions. But there are so many other resources online that associations can find out information about an owner. So I would, you know, encourage you to, there's Merlin, there's Accurant. I mean, there's probably 30 different resources where you can find out about someone's credit. Okay, next question. How can current architectural committee member be removed? Good question. The board typically appoints your committee members, typically right after the annual meeting. I have seen this before. I think it's better just to let that person ride it out for the year versus removing them. You're no longer on the architectural committee. I mean, it depends. I'd have to look at the circumstance. Like if they're just totally blowing it off and they're not responding to requests and it's putting the association in a bad position, you know, I may suggest that the board write them a letter saying, we appreciate your service, but we're going in a different direction, somebody that can give us more time. But taking somebody off a committee can turn into a real spiteful situation. So we got to kind of look at when's the next annual meeting? Is it in 60 days? Let's just ride it out type of thing. So I would strategize before I make that decision how you're going to proceed. Can a board have a vote using a ballot sheet not seen by the audience? Voting on a management company. So this is a regular board meeting. So can they vote using a ballot sheet not seen by the audience? Yes, the board can vote on it, but after the meeting, an owner could request to see that document. So good question. What language can we use in the CCRs to prevent someone from operating a rehab center out of their home? Drug and sex offender rehab. Ooh, that's not good. Okay, so under the Fair Housing Act, group homes are a protected class, a protected and allowable class. And so we cannot, as an association, discriminate against group homes. And so if you have a home in your neighborhood that's being converted into a group home, such as a home for the elderly, a home for recovering drug addicts, you know, the sex offender one, which there's not much we can do under federal law. Now that is the first time I've heard the sex offender one, but I have heard the one for recovering addicts, and many, many associations have, you know, an assisted living group home in their association. So be mindful of that. You may want to check in with the city. They have to be registered with the city. So you may want to check to see if that particular one has been registered with the city. Options or alternatives to requiring a government-issued ID as proof of age. I've had this one a couple times, I think from the same person. Okay, so when you're a 55 and over community, at least one occupant in your association has to be age 55. One occupant in each lot or unit would need to be age 55. And so the question comes up, how can we have them prove that they're 55 or over? And so I typically ask for a government-issued ID because there's no way to falsify that. So what the question is, what are some alternatives to requiring a government-issued ID? I can't even speculate on it because I want something that I know that they're actually the age, you know, and I'd have to look at it on a case-by-case basis, I guess, to determine whether or not the ages could have been fixed in some way. Can a renter challenge a fine at a board meeting? Yes. Remember when we talked about the very first slide where we talked about the open meeting law? And one of the exceptions for the executive session is that we can go into executive session to talk about a fine or penalty that a tenant has on their property, unless the tenant wants it in the open meeting. So this would be where that would fall. So if you have a tenant that wants it in the open meeting, you have to put it in the open meeting. Now, in all the time that this law has been out there, I've never had a renter, actually I was thinking of owner in that case. Can a renter challenge a fine at a board meeting? No. If the owner wants to come to the board meeting and be heard on it, it can either be heard in the executive session, or if the owner wants it heard in the open session, we have to see it in the open session, but the tenant, no. And you will see that from time to time. You'll get a tenant who's upset that the landlord's climbing on them for a fine. We tell them to take it up with the landlord, okay? Our age-restricted CCRs require all lots to be 55 or over. 2 lots have children. Grandparents maybe have been awarded custody by the courts. How do we deal with this? That's a common problem. There was a recent article I read on that in a national publication. Okay, I think first you need to look at your documents to see if what they're doing is contrary to what your documents say. Sometimes it says in 55 and over communities that if you have somebody who's under the age of 18 who's there for 30 days or more, that it's a violation of the CCR. So it's a sticky wicket for sure. I had one association that felt really bad for the family, and they did a special amendment for them to allow that child to stay there. So we'll have to look at solutions. That's definitely not an easy question. Regarding the 15 cents per page charge to the members, does this include the treasurer of the board asking for documentation for the yearly audit, or the monthly financials from the management company? Can the treasurer or the financial committee review the originals without making photocopies? Okay, this person, it's unsigned, of course. This is dysfunctional. The treasurer, this is just dysfunctional because the board should have access to everything. So if the management company is trying to prohibit you from seeing the audit or to see your monthly financials, that's wrong. Okay, and I know maybe the person that wrote this maybe was scared to put their name on it, and that's okay. Can the treasurer or financial committee review the originals without making copies? Absolutely. The management company should be giving you copies of that upon request without a charge. Can you place a lien on a property for unpaid HOA fees? Not fines or penalties, just the HOA fees that are past due. Yes. Voting at an annual meeting. 2 years ago, our management company gave us a sample ballot that said we have to have residents sign the ballots. We mailed out the ballots, and we heard we could have had the ballots in individual envelopes inside a signed envelope. When residents come in, can we have them cut off the bottom signature and put their ballot in an envelope and give it to the person checking off names. Okay, that's a lot. So basically the bottom line on this is secret ballot. Okay, it sounds like they want secret ballot. Of course, the board can set it up as secret ballot if they want to. The one problem I'm going to say about secret ballot is it's confusing. I go to annual meetings, so I see how people screw it up. Like I was just at an annual meeting 2 weeks ago, and the homeowners kept writing their name, saying, you must have forgotten the line for me to write my name on the ballot. So unless your documents require it, I personally think it's best just to have the name on the ballot. But if your documents require secret ballot, you need to follow it. Let's see, okay. What the question here is, does anyone have a management company that they would recommend? Pays bills on time, honesty, reliable? Give me a call, because I obviously can provide some feedback on that. Secondly, this is a great opportunity to network. You know, we have the room. It's a good time to meet people here. And so maybe you'll be sitting with somebody that's very happy with their management company, or you're always welcome to give me a call and I'll give you an honest assessment of how I feel about the management company or who would be a good fit. Do you have an updated homeowner information form? I do. If you email me, that's going to be that you'll have the buyers fill out. Just email me and we'll provide it to you. Can you withhold records if the homeowner has not paid for previous supplied record pages? Yes, absolutely you can. They have to pay. And what you could do is you can say you can come and inspect the records, but we're not giving them to you until you pay the past fee and the new fee. But they would be entitled to inspect them, you know, but they can't get the new copies. What if you can only get 1 or 2 people to serve on the board when the bylaws call for 3 or more persons to serve? Is a 1 or 2 person board acceptable? Well, if your bylaws require a 3-person, you really should try to get 3 people, okay? I have the same question saying we have 1 board member, 1's not enough. 1's gonna get you in trouble because people are gonna think something's funny going on and there's no checks and balances, so definitely don't do 1. 2 is maybe manageable, only if you've taken extreme efforts to find the 3rd person and you just can't get anybody. But I think the bigger question is, what's our game plan going forward, right? Because things aren't looking good in terms of participation. So what sometimes we'll do in a situation like this is we'll send out a letter on my letterhead saying, hey, we can't find anyone to be on the board. What does this mean for our association? It means typically that you go into a receivership, right? And if you go into a receivership, guess how much the judge is going to have to pay the receiver? $40,000 a year. I've had 2 associations that have gone through receiverships. And how do you think that $40,000 a year is going to get paid? The judge levies a special assessment. So it's going to cost you. And once you put that out there and then you tell them it's not that big of a commitment to be on the board. It's only 1 meeting a month. Usually you get a few warm bodies who will, bait that. Can the boyfriend of a board member, homeowner, attend the HOA meetings? Oh boy. Unsigned. If they're not on the record deed, no. If they're appointed as a designated agent, yes. Okay, our management company wants everyone copied on all questions and replies. Is this a violation of the open meeting law? Wants everyone. I'm thinking maybe it's a board member thing. So our management company wants all the board to be copied on everything. Potentially, if you're making decisions, discussing association business, absolutely, it's going to be a violation. Do all ballots have to be secret? No, we just talked about that. Only if your documents require the ballots to be secret. And we're just going to take about 2 more questions because we have a lot of really good questions here. Fines. Is there a statute of limitations on fines levied but not paid? Yes, you have 6 years under Arizona law to collect on the statute of limitations for fines. Is there a rule of thumb for fine reasonableness? It really depends. It has to look at the violation, like we said with the RV example and the renter example and the trash can rental. What I don't like to see is like judges wouldn't like $500 for failure to trim your palm trees. Because to trim the palm tree, it's only $100, so I think that's not going to fly in a court of law. This is a good question. Is a HUD or Department of Justice complaint that was filed against the HOA and dismissed public record? Yes, that would be public record. Okay, and the last question is regarding open meetings, open committee meetings. Is the committee allowed to have non-scheduled meetings to keep homeowners from attending? I hate to end on that one. Okay, here's the rule on committee meetings. Our legislature, in their infinite wisdom, came up with the thought that, okay, if it's a regularly scheduled committee meeting, it needs to be open to the membership and members should be allowed to attend. But like none of our clients have regularly scheduled committee meetings, right? So I guess we have to really look at what was the intent. If your committee does have meetings, like architectural committee, my best advice to you is you should be noticing the meetings. If you're a homeowner in an association, which it looks like this person is, and your association committee is having secret meetings, maybe to keep information from you, what I would suggest is write a letter to the board or the committee and ask them to please notify you when the committee meetings are and remind them of this law and that they need to comply with it. Okay, that closes our presentation for today. Thank you so much, everybody, for coming.